Let's talk about something that happens all too often. You see a company, its finances look absolutely perfect on paper, glowing audit report and all. And then, out of nowhere, it completely collapses. So who's to blame? Today, we're going to dive deep into what happens when those financial watchdogs, the auditors, get it wrong. So here's the big question. Can you actually sue the auditor? I mean, maybe you invested your money based on their clean bill of health, and now it's all gone? Well, the answer, as you might guess, is it's complicated. And it all leads us into the very complex world of auditor liability. Okay, so before we can even think about lawsuits, we first have to get a handle on what an auditor's job is supposed to be. What are they legally required to do? And just as important, where does that responsibility stop? So auditors have this formal legal duty to a company's shareholders. Their job is to look at the books and report back on these key things you see here. Do the numbers give a true and fair view? Are they following the law? Now, they're meant to provide reasonable assurance, not a rock-solid guarantee that a company is going to succeed. But if they fail at these core duties, that's when the door to liability starts to swing open. So what happens when that watchdog misses something huge? Well, it turns out there are three main legal paths you can take to try and hold them accountable. And each one has its own set of rules and, honestly, its own set of challenges. This here is basically the legal battlefield. You've got contract law, tort law, and statute law. Now, while criminal charges under statute law are possible, they are incredibly rare. So for our purposes, we're going to focus on where pretty much all the action happens, in the worlds of contract and tort. All right, first up, let's look at the most direct relationship there is. The one between the auditor and the company that hired them in the first place. This is all handled by good old contract law. This one's pretty simple, at least on the surface. A breach of contract happens when an auditor just doesn't do the job they were paid to do, or they do it carelessly. If that happens, the company that hired them can turn right around and sue them for breaking that agreement. And in these kinds of cases, the key piece of evidence, the smoking gun, is almost always the engagement letter. It's not just some piece of paper, it's the actual written contract that spells out exactly what the auditor is supposed to do. It's the foundation for any kind of breach of contract claim. Okay, but here's where things get really tricky. What about when the person suing isn't the client? What if you're an investor who bought a ton of shares or a bank that gave a huge loan, all because you trusted a faulty audit report? You don't have a contract, so how in the world can you sue? This is where a whole different area of law called the tort of negligence jumps into the picture. You can think of it as a way to sue someone for being careless and causing you harm, even when there's no contract between you. It opens the door for third parties, people like investors or banks, to go after an auditor. Now, to actually win a lawsuit like this, a third party has to clear all four of these legal hurdles you see here. You've got to prove the auditor was sloppy, that their sloppiness directly cost you money, and that the loss was real. But the biggest fight, the one where most of these cases are won or lost, is almost always on that very first step. And honestly, this is a million-dollar question. An auditor could have been totally negligent, but that doesn't automatically mean you can sue them. First, you have to prove they had a specific legal responsibility, a duty of care, to you. This is the central puzzle that courts have to solve every single time. So how on earth do courts figure this out? Well, a really famous UK case from back in 1990 called Caparo Industries versus Dickman was so important that it created a three-part test that's still the gold standard today for figuring out if a duty of care exists. To have a shot, you have to satisfy all three of these conditions. Was it foreseeable that you'd be harmed? Was the relationship between you and the auditor close enough, what the law calls proximity? And finally, is it fair, just, and reasonable to hold the auditor responsible? That one in the middle, proximity, that's usually the toughest nut to crack. This slide is fantastic because it shows you exactly how that proximity test plays out in the real world. In the Caparo case on the left, the court basically said, look, the audit is for the company's existing shareholders as a whole, not for any random person who might want to buy shares. No proximity. But in the Bannerman case on the right, the auditor knew for a fact that the bank was going to use their report to make a specific loan decision. That knowledge created the proximity, and the bank won. And this quote from the judges in the Caparo case, man, it really lays it all out. They drew a very clear line in the sand. What they were worried about was opening the floodgates to what they called
liability in an indeterminate amount for an indeterminate time to an indeterminate class. Basically, they didn't want auditors to be sued by anyone and everyone who ever glanced at one of their reports.
So you can see the tightrope auditors are walking here, right? They're constantly trying to balance their duty to the client who's paying them against the potential risk of being sued by, well, the entire world. Okay, so let's boil this all down. What should you remember from all this? For the client, it's simple. It's about the contract. But for everybody else, investors, banks, you name it, it's way harder. It all comes down to proving this special relationship. You have to show that the auditor knew that you, specifically, would be relying on their report for a specific reason. And that leaves us with this massive, lingering question. We live in a global economy that is built from the ground up on trusting these financial reports. So the line that the courts drew all those years ago is constantly being pushed and tested. How close is close enough? Figuring that out remains one of the most critical and hotly debated questions in business law today.